Now, will the court ever give less than the amount the guidelines recommend?
Yes, but you would have to give the judge a good reason why. For example, if you live out of state and you have to buy a lot of plane tickets during the year to come visit your child, increase the amount could be if there are a lot of unreimbursed, uninsured medical expenses.
I see. So let's go back to what happens when you file the complaint, it gets served, and so your day in court arrives. How do you get ready?
You should make sure that you have a very clear idea of your financial picture and the other party's financial picture.
Okay.
Most of the information that the court will use comes from the court's document called a financial statement, and be sure that the amounts that you're putting down are accurate. Also, something else that can be useful, especially if you think that the other party is not being entirely forthcoming about their financial information, is a process called discovery. You would need to do that with the party, and you would want to make sure that you're providing things for the court, such as your pay stub, income you may have, proof of the cost of health insurance, proof of daycare or other child-related expenses such as that. You also should bring in your prior year's tax returns or W-2s for the court too.
And documents as well?
Strictly speaking, no, you're not responsible if you're the custodial parent for providing the other side's information. But you should make sure that it is available, and you do want to have that in case the other side doesn't, or
you actually go to the hearing.
On the day of court, you should make sure that you arrive on time, that you are dressed appropriately, and that you are respectful when you're in front of the judge and any mediators. If you don't arrive on time, the court can sometimes...
Right. And so I mean, let's go step by step. So you get there, you get to the courthouse, what do you do?
You get to the courthouse, you go to the registry of probate, you check on the list and see where your case is being heard that day.
Which courtroom?
Which courtroom or which session. And there, once you arrive at the designated room, you might sit down with court staff and try to arrive at an agreement.
And is that something that the court staff help you with, or are they more there to just sort of, I mean, they don't...
They can help you write up any agreement that you might have.
Now, what happens if an agreement's not reached? Because I'm sure that's the case sometimes.
If you don't reach an agreement with the other party, then you would have the right to see the judge. Sometimes that happens that same day. Sometimes you'll have another court date to come back and speak before the judge. When you're in front of the judge, it's important to remember that you have to remain that you should relay your financial concerns and positions very clearly to the judge so that they can make a well-reasoned decision about the child support amount.
Now, will the other party get a chance to speak to the judge as well?
Yes, usually the person who has made, and then usually the other side will have a chance to respond after.
All right. So if the judge does decide to issue a support order, when do the parties receive it?
About a week or so after the court hearing.
Oh, that's pretty fast. And so they get this order a week or so later, actually making sure it gets collected?
There is. In Massachusetts, the Department of Revenue Child Support Enforcement Division is the agency responsible for court orders. So usually after the parties finish in the courtroom, they would be sent over to the Department of Revenue to make sure that the DOR knows about their case and has their case information. So after there's an order in place, it's important to let both of the parties can be found so that they can both collect the money and distribute it. And
it will be taken out of the non-custodial parent's wages?
Yes, in most cases the money is taken directly from the...
So what happens if the non-custodial parent doesn't pay according to the child support order?
Well, that depends on the situation. In most cases, the Department of Revenue would try to do certain administrative remedies, such as revoking someone's accounts, suspending their passport until the amounts are paid, intercepting lottery winnings.
Oh, wow. Okay, so there's different methods they can go about. And so say all of those things fail.
It's necessary to bring the other person to court. and file a complaint for contempt for some judicial enforcement of the court's orders.
Wow, okay. Now, I know sometimes a non-custodial payment, or any person for that matter, but in this case a non-custodial parent, might receive really, monitored through the tax system. How does that affect child support payments?
Custodial parent who's working under the table should still be sending in the child support payments. If they fail to do so, though, then the DOR would try to take the remedies we spoke about. And
prove that, if you have somebody that's earning money under the table, there's a potential for them to, on any kind of financial statement, declare less money than what they're actually bringing in. And how could you prove that they're bringing that money in? If you
custodial parent could try to present some information or evidence to the court regarding the other person's lifestyle or their other assets that they may have.
I see. So it's not just pay stubs. You can kind of provide different things.
You could,
okay.
yes.
Now, how long does
The child turns 18 or finishes high school, but if the child goes on to higher education in Massachusetts, the order K3.
As long as they're
As long as there's
enrolled in some school?
Yes, as long as they're in higher education.
Wow. A non-custodial parent loses a job while they're, paying a child support order.
Then it's very important for them to go back to court right away and file a complaint for modification and ask the court to either reduce or take other measures to stop their child support order.
Feels a need to modify, they go to court, is that what you're saying?
Yes, yes.
Okay.
If there's any need to change your child support order, only a court can make a change to the order.
Okay, and so basically you go back and follow similar procedures.
You would file a complaint for modification.
I have to pay child support if the child is receiving welfare benefits.
Yes. It's important to remember that they do have to pay even if the child fits, and the money in most cases that's paid in such a case would go to reimburse the Commonwealth.
I see.
Up to the amount of the grant received, except for the first $50 a month, which will go to the custodial parent.
That was in effect in another state.
And the custodial parent lives here in Massachusetts and feels like they want some enforcement of that order, then they can ask that the other state's order be registered here in Massachusetts. And it
Now, but what if the non-custodial parent lives out of state? How do they ensure that the payment gets collected?
There are different enforcement remedies that can be taken. And if it's a case in which no order has ever been Interstate Family Support Act, in which a custodial parent could fill out a petition, usually with the Department of have the DOR forward that to the other state, and then the order would be established in the other state.
Well, it all sounds like, although there's a lot of details, there's a lot of structure to help people along the way.
Yes.
So we have just a couple about child support.
Child support is so critically important. It's essential to meeting the child's needs. And also, it's the law, so pay your child support.
It's not an option.
It's not an option.
All right. Great. Well, I'd like to thank staff for the important child support issue. Thanks, Tina.